Welcome, welcome, welcome. Good morning, good afternoon, good evening. Like we say, it all depends on the time zone from where you're watching us from. Karibu to the leader, courtesy of the Evangelical Alliance of Kenya and Catalid on Hope Media, Hope TV, and the social media channels. Today, if you're in Kenya or interested in Kenya, you know it's all matters Supreme Court. What next after the Supreme Court? To help prosecute this matter is my lady, Joy Mdivo.
That's prophecy, I receive it.
Yeah, he receives this prophecy. Joy is a lawyer. You've been a magistrate, and you've been involved in the political space. We're great and glad, so glad to have you.
Thank you for having me as well.
Asante, so let's dive into it. Matters Supreme Court, but what is the point or place of the Supreme Court in the political environment such as that we're in today? Why the Supreme Court?
Thank you for having me, and I do apologize for my tardiness. The often used phrase that we have had during this season, election is a process. I'm sure you've heard that phrase so many times until election is a process. And what Kenyans did is when we were laying down this process, we decided, when we were doing the new constitution, we decided that this process will have a termination point. Every journey has to have the beginning and the destination. No pilot takes off without knowing where he's going to land. And we decided that in our election processes, when we just do the voting, oftentimes we are unable to finish it with the IEBC. And so we said the final stopgap will become the Supreme Court, such that when you take your disputes all the way through the IBC channels, through whatever you have, if you still cannot get a resolution that makes sense to you, take it to the Supreme Court, and whatever they decide becomes the final decision. So the place of the Supreme Court in our election process, it's the final stop.
And it's the first call and also final call for presidential.
For the presidential vote, when you're looking to challenge a presidential election decision, we made it the first and the last port of call. And the reason for that was quite deliberate, was so that there is no protracted, because if you start in the superior courts, so let's say you are an MP and you file in the High Court, then you go to the Court of Appeal, you still have the Supreme Court to go to. But for the presidential, because this race is one of those ones that needs to be determined, somebody sworn in and goes into office immediately, we decided in our wisdom as Kenyans that the first port of call will be the last port of call. And that is why you find even how the hearings are conducted are very prescriptive. So the timing that the Supreme Court has been given, the ambit within which they must make the determination, the issues to be determined, so that they don't have too much wiggle room. All they have is receive the petition, you've got 14 days, deliver a verdict. And whatever you deliver is final. So everybody knows that by Monday next week, whatever the judges pronounce, Kenyans accept that, and either a week after that, we have a new president sworn in, or 60 days after that, we have a new election.
Now, very interesting. Let's look at the scenarios in terms of, you can guide. I'm so glad that we've got a legal mind here. Is that he who alleges, the burden is on them to prove. So it's not for me unless I confess the allegation that you're...
Yes. He who alleges proves.
Proves. Now, how do you then filter the criminality within petitions from the political, underpinnings?
Okay. Every judicial officer has been trained to decant what we call ingredients of whatever you're looking at. So if you're looking at something that is criminal in nature, they're the ingredients that prove a crime. There's something else that every judicial officer is very mindful of. It's called jurisdiction. This is the legal space within which you can operate. So you might be a judicial officer, but let's say you're one court and I'm another court. I can't leave my courtroom and come and purport to hear matters in your case. I'm like, no, I'm interested in that matter. Edmund, get off the seat, let me sit in your seat, and now I'm your court. No. Everybody has the jurisdiction within which they operate. Another thing that judicial officers are also very mindful of is the capacity to deliver. So there's a saying that it's a practice. you can't issue court orders in vain. So whatever you ask the court to do must be something that, one, they can deliver their jurisdiction, and that it's not in vain. So, for example, that's why you'll find if you're filing a matter of something that's already passed, it's already been taken care of, that one is dismissed initially. So I'm sure even in this particular situation, Kenyans saw, for example, there are some of the petitions that were filed that were dismissed. And they said, you know what, this one can be better canvassed in the superior courts. That's the High Court and the Supreme and the Court of Appeal. Or these ones should actually go to the lower courts, should go to the magistracy. Or this one should go back to the other duty bearers, the DCI, the DPP, because it's not just whatever you ask the court that they go ahead and grant you. So in the current scenario, talk about the Supreme Court. And you're not just talk about the Supreme Court as the apex court, you're talking of the Supreme Court as an election court. Now, in the Elections Act, there is a section that talks about how the court conducts themselves when they're sitting as an elections court. However, the Supreme Court has got one extra layer because they also have what is provided for in the Constitution. So they not only have to look at what is prescribed in Section 80 in the Elections Act, they also have to look at what is prescribed in the Constitution. So as far as the Constitution is concerned, the reason you're given 14 days is because we're asking you to make a simple determination. Was there an election? Was it valid? What that valid election? Did it produce a result? Was it the result that the Kenyan people intended? And that result that was delivered, did it meet the threshold for one to be declared a president or not? Once they determine that, everything else now is distributed to wherever else it needs to go. And it's important for Kenyans to temper their expectation because there are some of the prayers and some of the requests that were made. Even yesterday from the questions from the judges, you could tell, they were like, okay, so we're not taking this lightly, but we just want to know how exactly you intend for us to do this. Because like I said, they can't make court orders in vain. So that's part of, I think, what Kenyans need to understand, because by next Monday, we need to have a decision. And you can't have a decision if the asks are too many, and they're too out of the scope. So it's up to the judges to prune as much as they can to be left with what they must deal with constitutionally by next Monday.
And I imagine this then is from all these petitions which had a timeline by which to file.
Yes.
Or make applications to be Amici, hey, that
Amici.
one. That one. Friend, buddy
Amici
of the court.
Yes.
Okay? And so I imagine that the first thing they did was to look at all the petitions,
yes,
and ask themselves, what are these petitions about? And then now consolidate in thematic areas in terms of the asks. Now, even though the petitions may have come from different quarters who may not necessarily have caucused to send petitions, you send. Now, it means that if thematically you've been grouped together, then it is, I imagine, incumbent upon you to now meet and have a sense of what your game plan in terms of strategy. Because now, at the Supreme Court, you now find the 9 areas as distilled, where the last one was something like orders that the court may, or that is to give room that they can now say, Ina kusindikiza, despite all these thematic areas, is that then you as a lot are allocated 3 hours, 3 hours, 3 hours. How you distribute, how you prosecute it within that is up to you. If one person takes 90%, then that is to your disadvantage if you didn't get to the crux of the matter. How then, if you're to advise or comment on how the consolidation of the petitions should then be prosecuted?
Okay, because the court only has 14 days in which to determine all the petitions that have been raised, it is expedient for them to actually combine them. So what happens is this. Once upon a time, in Kenya, we're very strict about something called locus standi, the place of suing, that you had to be directly aggrieved for you to be able to sue. So that would mean only the presidential candidate would be able to sue, or maybe the IBC, because they also are directly affected.
Yes.
But when we passed the new constitution, we opened it up and said, you know what, any concerned Kenyan who sees anything that they feel does not fit in with the constitution has a right to petition the court for the matter to be heard. And hence the rise of people like Okiya Omtatah, who are able now to go to court without being advocates, without even, as long as I've seen the DPP has done something that I don't like, I'm able to take it to court. So what that has done, therefore, is when you have got a situation like this where there's an election petition, I think you saw some of the lawyers who are representing ordinary Kenyans.
Yes.
People who just had a question and are like, you know what, did my vote really count?
Yeah.
I want to know if my vote really counted. And the court can't say, you know what, you are not a political player, sit over there, we'll get back to you tomorrow. They have to hear everybody. The easiest way, therefore, is to look at all the petitions that have been filed, and this they did as soon as the petitions came in. Them and their team sat down and looked at all the prayers, because it arose out of the similar process.
Yes.
So you would find an overlap. And that's why you find that the courts decanted and said, you know what, these are the 9 questions we feel ought to be addressed. Now, what is different this time is that the court came up with the 9 questions by themselves. Usually, I think what we saw during the Maraga time, it was more like you guys come up with what you think are the agreed questions and then now try to moderate the process. But I think what we have seen with Judge Martha and her cohort is a lot more efficient, because what they've done, they removed the push and the pull, and even instructed the litigants and told them, look, what we expect of you is compliance. We are not expecting pushback. It's not a discussion. What that did also, it focused the people who are making presentations. So whereas you could have come to court and you are so aggrieved that you complain about everything from the carpet to the screen to the, you are just unhappy with the.
You're just emotional.
But if I tell you, you know what, just think
Focus.
about this cup.
Yes.
Tell me why this cup is such an irritant. It doesn't matter then what else you're upset with. You have to focus on a particular issue. So decanting the issues helps the parties to focus. And by giving them a time span, what you saw yesterday, for example, was a lot less legalese. Because to be honest, a lot of that is what we call playing to the gallery. You just want to show people that you know a little bit of big English. So when you've got an opportunity, you want to talk and hold your robe and, you know, turn and say, do you get the point? Have I confused you enough or not? But because you now have 15 minutes, 20 minutes,
Focus.
you have to hit your point, because that's the only chance you get to hit your point. Then you raise the question about the Amici Curie. The Amici Curie are people who feel that they can add value to the process even though they're not parties. And say, you know what, we are the Law Society, or we are the International Commission of Jurists. We do law. This is our bread and butter.
Or I'm an ethical hacker. I know how to hack systems.
Yes. So we can help you shed the light into this. And now what the court decided with those is, whatever you have to say, reduce it succinctly into writing,
Then give
and we will read it. So what that does, it frees up more time for the others who need to go. But you see, in the consolidation, they said that there is a lead file. And that was done because there's one file they looked at that had the bulk of
the issues,
of the concerns.
The concerns, right.
And the people in that file also stood to be aggrieved the most, and so needed to have more attention provided and more time given to them to prosecute their matter. That's why you find these others are given 15 minutes, but these fellows are told, you know what, for you, because your matter is heavy,
You got 3 hours.
you get 3 hours. You get to have 4 lawyers. You get to. The other thing also was the limiting of the number of the lawyers, because I think before that was a major weakness, where every party came with a battery of lawyers and everybody wants to have their day in front of the camera. So I think what we have seen with this particular process was a lot better managed, freed up a lot more time, because the judges were on their feet by, I think, 6:30, 7, they were on their feet.
Yes.
That was, unlike previous times where they would sit much later into the night.
Yes.
And what that does, it gives them time to go and burn another 4-5 hours of deliberations.
Oh, yes.
They're able to start writing the judgment, as it were, because from the first time you start listening, you start reducing what you think are the congent points, so that by the time that the respondents come today, they add on the balance, and then now in the next 3-4 days when they caucus, everybody has their points in hand. I think you also noticed that what Judge Martha did is the judges themselves were also instructed to not interject when the people are presenting.
Yes.
So unlike previous petitions where you'd say something and you'd see the judges challenge you there and then, this time around we saw the judges hold their peace the entire day,
right until the
and
end.
everybody noted
took
down.
notes. Yeah.
And the judge, now the Chief Justice said, okay, every judge in turn raise, and they would raise questions from Murgor in the morning or from, so you realize that the judges themselves were also under instructions don't interject, don't interrupt unless something. So you would see the interruption would be to sort of guide counsel back, and then they step away. So I think the management this time around has been a lot more efficient, has given the parties a lot of time to distill what they need to do. The parties also given direction and told, you guys get one other bite of the cherry, another 15 minutes of rejoinder. When you come back, tell us about this. So I think that should help Kenyans understand what is going on at the Supreme Court right now.
And I think that builds confidence in that arm of government. And,
it does.
And confidence building is, again, a matter of trust. And in this country, we have a lot of that trust deficit.
In politics.
Now, having said that then, you find that, like, yesterday was for the petitioners, today is for the respondents.
The respondents, yes.
And then Friday, what can we expect on the third day now?
The respondents today have an opportunity to do two things. If there's anything raised yesterday that they need to debunk,
they have that opportunity.
They have the opportunity.
But still within the 3 hours, within the time that are allocated.
Yes, within the time allocated.
Yeah.
They have an opportunity to debunk it. And if they've got any evidence that they wish to adduce, again, this is the opportunity. So they get a lot less time than the others because primarily, like you said, the ones with the burden of proof to discharge need a little bit more time than the ones responding. But be that as it may, plenty of the concerns raised yesterday, you find are overlapping. So if somebody has already debunked, so for example, if the IBC lawyers have already debunked something, Chebukati's personal lawyer doesn't have to come and debunk the same.
But it's already been dealt with.
He can say, you know what, I associate myself with Edmund's submissions, and I fully concur with what he has said, and I have nothing useful to add on that score. So let me deal with this other score. Then there's also the concern about were they given less time, and I think you saw S.C. Ngatia raising that. And the judges explained and said, look, we have looked at every content weight. There's nothing that says if he gets 1 cup of tea, you also get 1 cup of tea. If we think you need a 3/4 cup of tea, he'll get 1 cup of tea, you get 3/4. And that is very instructive to just show you that the judges were mindful of how many issues are you really prosecuting?
Yes.
And in allocating the time as compared to he said, she said, we get, they get, which I found was it was quite progressive because what it does, again, it forces you to focus.
Focus, yes.
But you'll notice also on the respondent side, there are not as many as there were in the petitioner side. So it also makes sense that if they collaborate, and the point that you raised earlier, that collaboration, like for example, the IEBC lawyers and Chebukati, I would imagine, must be working in, even if not in the same boardroom, there must be a shared WhatsApp group somewhere.
Yes.
Because a lot of the issues that they're going to raise are going to cross-pollinate. Then there's the
and it's in their interest, they're on the one side anyway.
Yes,
right.
And you saw the other commissioners were each given 25 minutes. They were given an hour to share. So even the 3 on Chebukati's side, you would expect that they'd have the same sort of balance. But in the afternoon, something interesting will be happening. The scrutiny that has been happening with the boxes
at the Supreme Court,
at the recounts at Forodha sub-registry, as well as the scrutiny at Anniversary Towers, the judicial officers who are overseeing that processes will be delivering the reports in the afternoon. Now, that is also important because once those reports are delivered, then those who are coming back to respond tomorrow, and I would imagine even the respondents from today would be given a chance to respond according to their pleadings, based on what they have seen, to sort of make a comment about it. So, for example, if in your pleadings you made a comment about the validity of some votes, and now you have this report that has come from the judicial officer who was overseeing the recounting of the votes, you can say, look, I already said that the votes did 1, 2, 3, 4, 5, and look at this report, it corroborates what I was saying.
What it is that I was saying.
Or it completely debunks what was being said. So,
or you may not amplify it if it doesn't quite add to what you thought it should have.
Exactly. That's how it works, unfortunately. you make a microphone where you want to be louder, and where you don't want to be louder, you mute.
You unapunguza volume.
You unafinya remote una mute. So those reports will be handed in this afternoon. And I would expect that would make for interesting reading because the Supreme Court, the servers being opened at the IEBC, you saw even yesterday there was a little bit of a push and a pull with the advocates. Again, you saw the court stepping in and saying, we are not taking the cues from you, This is supervised by a judicial officer. We will wait for the feedback from our team
Yes.
to know if there is a problem. So it's not up to you
It's not
to.
up
You
to
can
you.
raise your concerns, but
your
we will.
time, but-
But we will respond to the
Yes.
report we get. Our report is that there is progress, and it is good progress.
It is happening.
And that is what we are relying on. So you can see a very different tenure this time around. The judicial officers are very much in control of their courtroom. And that, like you said, it lends confidence. Because if they were able to just be told anything and they just react,
They get
however,
lost and become players as opposed to being,
and even us would start getting concerned. We start saying, oh, the way he responded, it must mean. But now they're being firm with everybody. There's nobody who's getting away with any favors. So, like for me personally, I'm quite impressed at how Judge Martha and her cohort this time around have carried out this
charge,
process.
yes.
And it's also been very easy for the normal Mwananchi to follow. Unlike those ones before that were just nothing but legal jargon, this time around, people are actually, like the engagement we had before, people you can tell are actually understanding what is going on, which for me is excellent, I think.
And like you say, it is less legalese, more common speak, because it doesn't then remove the key person in this discussion, the voter. Because, it's like we played a part, now you guys go and do yours and come back to us yet. We're the ones that matter. It's the voter. It's about the voter.
Exactly.
It's about the voter. It's about the voter. Now, the scenarios of outcome and the environment in which these scenarios would be happening. What are the possible scenarios of outcome without necessarily speaking to what is being canvassed?
The merits.
Yeah, the
Okay.
merits or demerits.
Like I said earlier, the jurisdiction of the Supreme Court sitting as an election court would have been in the Elections Act. Any elections court, so whether it's the magistracy or in the High Court, wherever the challenge has been raised for MCA race or whichever, they have several powers, for lack of a better word. So they can order scrutiny of the material. So scrutiny goes from how many voters were identified, how many ballot papers were plucked out, how many were unused, how many. So that is scrutiny, where you're
Yes.
looking at everything with a fine-tooth comb. Or they could order simple recount. Just open the box, let's count them again, and let's see. They could order a retally. Retally now would be happening maybe for a race that has got a constituency-wide or a county-wide. Because, a ward is just one
It's
unit.
limited to that.
But retally
locality.
is where you're collecting from several
different
places,
layer,
and now
yes.
you have to do the math. So they can order a retally. So you're not counting the votes one by one, but you're looking at all the Form Bs.
Yes.
And then adding up the Form Bs to see whether the Form C that was generated to declare the winner is valid. So as an election court, they can do that. But with the Supreme Court, like I said, their role was very prescriptive in the Constitution. And the Constitution told them, forget about what you do as an election court, because when the Constitution and the statute are at variance, the Constitution takes precedence. In the Constitution, the Supreme Court, sitting as an election court, has been given only two options. You can either uphold the decision that was announced by the IEBC or annul it. So based on those two scenarios, then there are no other orders that can be made. So for example, yesterday the order granted in the interlocutory applications, those preliminary ones, was an order, a recount in various polling stations as a sample to see whether the question about the vote tally, because we're saying there were allegations about some tallies were higher than
others less and
yes.
correct and so.
So the court picked a snippet and said, you know what, let's pick this, let's recount this. So they didn't order a recount of the entire vote. So we are not even expecting that one of the orders that they can make is a recount of the entire vote. They will use what they have in this snippet as a sample to make whatever determination that they need to make. So either uphold what the chairman said or send the Kenyans back to the polls. Those are the only two possible scenarios.
The scrutiny, verification, tallying, those 15, how are they selected? Who prayed that these are the ones that you could? Is it by the side of the petitioners or in those who may have respondents said?
No, it's one of the petitioners. It's
Yes.
one of the petitioners who, there's somebody who sworn affidavit in support of a petition, who singled out specific polling stations as areas where there was
They believe that they had
they believe that there was a problem.
malpractice or problem.
And they went ahead and indicated what sort of problems that they had identified. And so the court said, oh, these ones here where she made a comment, we want to see those.
Yes.
So you saw an attempt by some of the other petitions to say, oh yes, even Asgays want to this and that, looked at, and judge made a decision and said, look, we made this very specific order because of a very specific pleading. Anything that was not in your pleadings, you're not coming up with now.
No.
So take back your nice letters and thank you very much. So you can tell that it was based on something that very specific that was raised. So there's something specific that the judges are looking for. So it's not a random, they didn't just pick some random and say this is a sampling of the votes. No, it's because there's somebody who raised specific issues regarding those particular polling stations, and that's why those particular polling stations were picked. So it was not a random
sampling.
Let's see which ones you can.
Iki Piki Ponki, that one.
Oh yeah, Pakamielo disco. No, it wasn't a random. It was actually in response to something raised in an affidavit and specific issues raised in those polling stations.
Now, just to help Kenyans or those who are watching or tuned in to appreciate the rationale on uploading the Form 34As. First of all, what a Form 34 is. I remember in the ECK it used to be, is it 31B? There was a form that was famous or infamous.
Yeah, it was, but even last time it was 34. But before that, it used to be an A16, 16A.
Oh, yes,
presidential.
yes. So now,
in the ECK days.
What is the Form 34? Because we go back, because the voting happens at the polling station, and the results, as announced at the polling station, is final. There's nothing of provisional for adjustment. Even if in the process of counting, in tallying, there are errors, who then has authority to change, if at all, by way of individual or institution, but errors that are noticed in that journey, how are they captured, and should they be demonstrated at the end? I.e., I'm suggesting, correct me if I'm wrong, that at Bomas, you may come and tell me, you see, 1 + 1 is 2, but here, this shows 1 + 1 is 3. Me who is at Bomas, I will still take 1 + 1 is 3, but make note. And, you know, how then does that affect the final tally at the end? Because there are those who then may be very prescriptive, say, 1 + 1, you see, the wrote, it is, if they can't get that mathematics right at that pace, then nothing else can be right in the process.
So when the IBC set up the portal, it was in response to the criticism in 2017 that their process was not transparent. So one of the decisions that they made is that whatever they receive as provisional results will be available for Kenyans to see.
And the provisional to the extent...
The provisional to the extent that...
has not been determined at the end.
No.
That,
they're
yes.
provisional to the extent that until Chebukati declares
then
that it is
final.
the one, then that it becomes
Okay.
final. So even if it cannot be altered, you will not call it a final until
He's
it's pronounced, or one
right.
of the commissioners pronounced. So that's why you see the commissioners coming out and saying, we have results for the following polling stations. We had been seeing them for 2 days on the portal.
But until they do so,
but until it
is not final.
Yes.
Right.
So what happens is this. According to the Mainakiai case, like you have correctly stated, the result at the polling station is the final result. Meaning Chebukati and the IEBC has no role in determining what the final result is. All they have a role is in collecting all the final results and combining them into one grand result. So the Form 34A is that form that is filled, you know that station where you cast your vote? When you're done casting your vote, that box is overturned there on the table, is counted, and once it's counted, it is filled. That form that is filled there in that classroom where you voted, that is the 34A. And what they did this time was, they married the KIMS kit geopolitically to the polling station. So that the KIMS kit where you are being identified in the polling station could only be used in that polling station.
Transmit only from there and no other.
And then that KIMS kit that identified this particular batch of voters would take a photo, having identified some security features in the Form 34A. Because remember last time people were taking photos of foolscaps with rhinos drawn on
Yes,
them and
all
stuff
manner
like
of
that.
things, yeah.
So this time around, there was a security feature installed in the Form 34A that the KIMS kit would identify so that it knows that that's a
That QR
legitimate
code,
Form
that this is
34.
only locked in for business.
Yes,
Yeah,
and
right.
so once it takes the photo, it then sends it. That's why the 3G network was important, because
Transmission of that.
it transmits the image,
image,
to the
yes.
portal. Once the image is received in the portal, now that's what Kenyans were able to see. Because as soon as it is received in the portal, what Chebukati did was, what was received in the portal, as he was able to see it, you were able to see it on the IBC portal. So that was the role of the
Meanwhile,
portal. was
the analog
transparency.
physical one that was filled was also coming by road.
So once not the guy finished in the polling station, they collected everything in the constituency tallying center.
Go to the next level of
Then in the constituency tallying center, there was a constituency RO, returning officer, who collected all the 34 A's from all the presiding officers in every polling station, put them in a file, and he had to physically accompany them to Nairobi. And until he got to Bomas, and then handed it over to the IEBC officials, now the staff members in Nairobi, handed them over and had it scrutinized. It was only after it was scrutinized that he was released to go. So it was a very big ask of these returning officers. So when they arrived at Bomas, this is what they would find. They would find an IEBC official sitting there, and they would find another IEBC official with a laptop. Because what happened at the constituency tallying center is once he received all those Form 34As, he inputs the results and generated, it was an auto-generated one, Form 34B.
B, right.
So the Form 34B had the constituency results all tabulated into one. So he got to Bomas and found somebody with a computer looking at his Form 34B that he has generated, and somebody else would receive his physical Form 34As. The IBC staff, therefore, would verify what has been received physically against what has been reflected in the Form 34B. Now, the Form 34A is sacrosanct. Once it has been filled and the agents have signed at the polling station, it cannot be changed. The only one that could be adjusted was the Form 34B, because in inputting,
there could be an error.
There could be an error. So somebody may have seen 191, but the one was written on the line. So he input 91.
91, yes.
But if you look at the physical, you're like, oh, no, actually it is 191.
Yes.
So you can adjust the 34B, but you cannot adjust the A forward. The only way you adjust the A is if you go to court and say, by this polling station was an error. That's the only way you can. You can't countersign, you can't. So what is in the A, Ndomusho Alami.
Right.
But the process of verification by the IBC officers was being observed by agents of all the political parties.
So the ownership of the process was IEBC, only that the agents and observers were, in a sense,
eavesdropping
on that.
Yes.
It was not a forensic for them.
No. You could raise a concern because you have the same forms that they have, because the returning officer would arrive at Bomas, take photocopies
and you're given.
Take photocopies of them and hand them over to you. So even if you didn't have copies, you didn't have agents, so you didn't have copies, they would give you copies of what they have come with.
Right.
So as this person is tallying, because they would read it out loud, Sitam polling station, Joy 15 votes, Edmund 10 votes. And as they're reading, the person in the 34B is counter-checking
against what
has been entered.
Right.
So if he hears Joy 10 votes, like, is it 10 or 110? 10. Let me see. So they look at the form. Oh, yes, it is 10. Then they go ahead and correct. Once they have gone through all the polling stations, then is everything done? Yes. Then he clicks now, verified. Once it's clicked verified, again, on the portal, Chebukati now would look at the ones that have been verified, or rather the commission would look at the ones that have been verified, and now add that to their tally. So that's a process that took 5 days. Was it 5 or 6 days to do? Because it was it was like pulling teeth. It was painstakingly long. Because everybody, those 46,223 polling stations had to be verified one by one until they were done.
Quite a process. Quite a process.
If you ask me, we have found an easier way.
Now, when you look at the scenarios of outputs, either affirm or invalidate, which means rerun. Rerun, if it's a farm, 7 days thereon, 13th, we have. Otherwise, it is 60 days.
60 days, you go back for a rerun.
Now, that then becomes very interesting in terms of the scenario because the constitutionally mandated body to hold elections is the same one that also could have been cited for illegalities and irregularities still this time. But would it be to an extent that it then casts doubt on their capacity to hold a rerun? And even as a rerun is being planned for, we don't have vacuums at the presidency. People tend to look at the president, but I would beg that we look at it as the presidency, because the presidency, one of the personalities in the presidency, even in incumbency, occasioned by a rerun, is also an interested party in the rerun. Does the DP, as at now, because he's technically a holder of 2 offices, incumbent, outgoing, deputy
president.
potentially incoming.
That is true.
So if the incumbency continues to the extent of the DP as per them being elected in 2017. Now, here's the question that I'd like to pose. Is it deemed that he has resigned? Because then you can't have a vacuum in the office of the DP in a presidency that was a joint ticket, even as you're planning or anticipating a rerun. Then speak to the referee, the organizer, the IEBC, where another scenario can come, that the person of the chairperson is cited not worthy of holding office.
The Constitution is very clear. Let me start with the easy question. The Constitution is very clear as to who has the mandate to conduct elections in Kenya. It's the IEBC. There's no ifs or buts about it.
It is that's clear. Nobody else, not the Supreme Court, it is the IEBC.
The Supreme Court cannot tell the IEBC what to do or how to do what they need to do because of the word independent. The IEBC is supposed to conduct its duties independent of too much or undue interference. So you'll find the courts will issue judgments here or there regarding this or that, but there are times when you have found the IEBC just simply going on appeal and disregarding and carrying on to do what they need to do, because the duty to deliver an election result is theirs. Whether or not we think that the chairman is competent is immaterial at this point. Because if you'll remember in 2017, in my opinion, was a much worse managed election than this one. But when a rerun was ordered, it was still Chebukati and Chiloba who delivered the rerun. Because the mandate is still theirs.
Right.
There is a reason why we made our constitutional commissions have something called security of tenure. It's so that they're not at the whims and the mercies of the players in the field who say, because we had been treated to that, Edmund must go, Joy must go, you just do something tomorrow, the Attorney General must go, the judges must go. Remember, police will be sacked at lunchtime.
Yes.
I mean, you're busy sitting at your desk and you're doing things, and the next thing, I mean, civil servants never used to miss the 1 o'clock news because
it could hire or fire them.
Yeah, I mean, you could be sitting there thinking that you have a job, ukishuka chini hata gari imeenda, and the askari has gone. So we became conscious of that element of abuse and insulated them. So what that means, for you to remove an IEBC commissioner,
there's a process that must be followed.
And the process is rigorous.
Yeah.
Because, truth be told, if there was a way that they could have removed Chebukati between 2017 and now, they would have done it. But it's hard. So they tried to induce him to resign. But he didn't. He eyeballed them and he stayed put. So even now, if the court decides that they're annulling the decision and we're going back to an election, truth be told,
it'll still be IEBC.
It is still IEBC. And not just Chebukati, even Chererafo.
Yes.
There's nowhere they're going. They are properly in commission.
They are there.
they have security of tenure as well. However, mathematics has changed them or not, it does not matter.
They are there. That's
They are
right.
aondo wako.
Ndio.
And so Kenyans just have to get used to the fact that once you give constitutional holders office, unless they willingly lay down their lives like Jesus,
We have to deal with them.
wazoe. Zoe hiyo sauti. So as far as that is concerned, I think that's something Kenyans need to settle. The judges yesterday, remember, asked some of the guys, how do you foresee us fulfilling some of these requests that you have made? One of them being that one of, I mean, you tell us, maybe you have seen something that we haven't. to make
Tell
this
us,
possible.
let us, so that we can.
So even me, I'm waiting to see. But
Show us.
from my reading of the law,
That is not.
the person with the mandate, the legal person with the mandate to carry out an election is the IEBC. Do we have an IEBC? Yes. So even if we go for a rerun,
It is still that
them.
body.
But even if we are minded to replace the IBC at this time, it's almost impossible. Because you did say
Yes,
that we have
yes.
the president
Yes.
in place, but you
Yes.
forget that the president right now has got what we call
Yes.
he's got temporary incumbency.
He cannot appoint public officers.
He can't appoint public officers at this point. He's at a space where he's maintaining.
He's just cruising. He's on,
Right now, it's
he's
on
in cruise mode.
It's the plane is about to land.
Yeah.
So he's already taxing. The fasten your seatbelt lights are on. Everybody sit down and wait. We are about to land this thing. So at this point in time, he can't be told, oh, by the way, and pass by Madrid before you get to JKIA. No, he's already seeing the runway. He's already under the clouds. He's already taking this thing for landing. So right now, the only thing the president can do is, just make sure that the country is safe. If there is somebody who comes and tries to declare war, he's still commander-in-chief. He can still tell the army, you know what,
Yeah.
go and defend our borders.
Yeah.
But he can't really appoint, the process of appointing new commissioners right now, he cannot initiate it because usually he's the one who would kickstart the process. Then Parliament now would form a select committee. Then they would invite applications. Then Parliament again would vet. Parliament has also not been sworn into office. They're waiting until next Tuesday. So you don't even have a parliamentary committee to be able to form. So the 60 days within which you have to do a rerun,
You cannot change IBC.
you can't change IBC.
In any case, even if you wanted to, it's a political process also to the extent it must go, you can't do without parliament.
Yes.
Now, when you look at the composition of parliament and the interested parties in parliament, of course, they'll be aligned to what will be contestation at the presidential level, which now will again become protected, I can anticipate.
And which is my biggest criticism of how we populate some of these offices. We allow the politicians to pick the referees in the game. And what happens is, whenever something happens, then we go back to who sponsored this one to get there. And that's where you find accusations of this one is working for this party, this one is working for this party, this one is working for so and so. Because all those guys are there courtesy of some patronage or other. Until we get to a place where, as Kenyans, we have to get a crop of leaders who will be unselfish enough to allow the processes to be done by somebody else other than the politicians. Remember, this is a hangover from the IPPG days.
Yes.
Where we
yes.
say minimum reforms, let you bring 3 people, you bring 3 people, then they work together and everybody of us is satisfied that
Because they come
there's
with
someone who
interests. Yeah.
But where we've reached now with the independent institutions, honestly, the patronage from political parties has to end. The divestiture that political parties have in selecting who becomes what has to end. Because every time something happens, we always remember Flani was sponsored by this party to get there.
Yes.
Flani was sponsored by this party to get there. And that's why we end up in the morass we're in. And also, until somebody, for example, like Chebukati, has been through hell and high water since last time. So I think he's gotten to a place where he's ready to eyeball anybody because he's thinking, I'm leaving in January.
In any case.
I have a legacy that I want to protect.
Yes.
So even if you call him and give him threats and innuendos and for him, he's looking at bigger picture. I have got a name that I'm building. Some of those who've just come into office may not have the same strength to resist the pressure as much. And so you find we have done bad things to ourselves. And politicians have to become unselfish enough to allow Kenyans, for example, if you're recruiting members of the IBC, can they be from somewhere other than the political space? Can they not be political appointees? What they need to do is deliver an election. They don't need to run political science offices. They don't even, you don't even need to have their numbers. So that's something I'm hoping that they'll release from us eventually.
Which then speaks to we as a country in this protracted, because that's really what it is that you're doing. We're still being, we're still at crossroads, parties, and the country is still literally being, split down the middle. And we need to get through this, whether in 7 days after Monday or in 60 days. In any case, even in 60 days, it doesn't suggest that there'll be no petition. So then you can end up having a cycle of issues as we're still continuing. But you must have faith, the place of the Christian profession, such as yourself and others in the faith. What should we do? How do we become salt and light? And we're all Kenyans.
No, but the one thing that I'm grateful for is that this time round, Kenyans seem to have grasped the unity card with their hands and feet. Because unlike before where there was, yes, political temperature, you would see it played out in public life. This time Kenyans are very unconcerned about that. Yes, we have our political preferences, but look at Nairobi.
And rightly so, which is, you're right, Abid.
Yes,
you should.
Kenyans have decided, you know what, you guys take this to court if you don't like it. Us would be happy if you succeed. But even if you don't, by the way,
we must go on.
our life has to go on.
Yes.
And I'm so grateful because that is not just a function of a lot of civic education, it's also a function of prayer. Because we prayed that, Father, keep the nation calm, keep people calm. That's one thing. Secondly, many Kenyans also divested of the success of our political leaders. We have realized when our political leaders succeed, it is them who have succeeded. we could be happy for them, but it doesn't increase the size of ugali on my plate.
Yes.
That's a very important realization for Kenyans, because before, people would go out and ban kiosks and do whatnot, and then tomorrow the kiosk you banned is where you used to get food from.
It used to employ you.
It used to employ you.
You have nowhere to go.
I remember post-election violence. I went to Kisumu about 2 weeks after the post-election violence. My parents were stuck in upcountry, so they left the car in Kisumu. So after it died down, we were bringing the car back to Nairobi. And the town was a shell. It was completely... Have you seen what Professor Nyong'o has done? Kisumu has come back alive. Can you imagine all that progress? And then people go and ban it. Even them themselves, they're like...
No.
That, in my opinion, we have to give God thanks. Because that level of political maturity, to say, you know what, I'm happy for you if you succeed. I'm rooting for you if you succeed. If you call me on me to vote again, I'll come again. But to come to the streets, that I'm not going to do. Things like recently when we were being asked to go and do vigils outside the Supreme Court, people prayed about that and said, you know what, Lord, this is a recipe for...
It's a recipe for incitement. I mean,
yes,
and you can't contain, you can't control. After
that
crowd. A spark and then...
And in short order, it was rescinded. So there are places where you can see God working to sort of help us to deal with our the fallout after the election. Even how the church has responded this time around.
Yes.
There's been a church that has been very partisan in the political space, but there are those who have chosen to hold fort and they have chosen to walk the middle line. We've seen our religious leaders pastorally visiting all the different candidates and offering prayer and support. I was heartened when I saw that, because I'm like, you know what? You have taken the lead in offering not just healing for Kenyans, even the political players are hurting.
Yes.
They are going through a lot. Just by going, sitting with them, having fellowship, praying over the family, speaking into that situation, is such a positive move. So in my opinion, where we are right now, even as the church participating in this process, I think God has given us a window. And I'm hoping that the religious leaders especially will keep up with the pastoring of our political leaders. Because for a long time, I think we just see them when they come and they offer michangos in churches and they go away. But that thing of visiting with them and sitting with them, and I'm hoping, because I'm sure it was a closed door, but I'm hoping when they sat down, they had some hard conversations.
Yes.
Asked for prayer requests, how can we pray with you? And for me, that tells me then the voice of God is speaking into the situation and is calming things and is bringing healing and restoration, such that even as a country, we have a bigger chance of coming out of this more successfully. So where is the church in all this? Of course, even for us as the professionals. Like I said earlier, wherever you find yourself, God has placed you. participate fully, praying over the situation. Like now, the guys were doing scrutiny yesterday. They slept there. There are those who took them jackets, took them food, who did what. That is Christianity.
Yes.
We need to just find a space and do what we can when we can. And at the end of it, God is glorified.
Amen. And that is it, because Christ is on the throne. Whoever we select, that is the process we have elected to choose. Let's respect it and still remain Kenyans at the end of the day, even after the Supreme Court process. Come 5th next week or 13th with the affirmation, if that so be the judgment, or 60 days thereon with institutions and individuals that we have. Thank you, my lady.
Thank you for having me. Thank you.
Yes, that is Joy Mdivo. Thank you so much for the insights, input, and opening it up. Let us cease being overly partisan, but respect each other. Thank you for the privilege of your time. This has been The Leader. Let's do this next week, same time. Asante.